Hi, I'm Rusty Adams. I'm the research attorney at the Texas Real Estate Research Center. In the last issue of TG, we talked about short-term rentals and what restrictions can be placed on them by private individuals through deed restrictions, restrictive covenants. In this issue of TG, we're going to talk about a different type of regulation by governments, such as cities and counties. In this article, we discuss several cases that deal with governmental regulation of short-term rentals. It's important to realize that the law in this area is developing, and so there's a lot of questions we still don't know the answer to. It's also important to realize that it matters a great deal how the case gets to the court. You can have very similar situations with very different results based on the facts of the case and on how the case is pleaded and presented to the court. With the advent of apps like Vrbo and Airbnb, short-term rentals are becoming more and more popular, and landowners like them because they have an opportunity to generate some more income off their property or to buy properties specifically for use as short-term rentals. Cities often want to regulate short-term rentals because they perceive problems in terms of large gatherings of people, parties, noise, parking, trash, and the like. Some of them attempt to do away with short-term rentals altogether. Some of them put restrictions on certain conduct at short-term rentals. As the law continues to develop, it develops when landowners challenge municipal ordinances, and there are various ways that they can be challenged. In observing how the law develops in this area, it's important to realize how the cases get to the court and what the courts will and won't decide in a particular case. And that's all based on how the case is pleaded and presented to the trial court and to the appellate court. Additionally, in reading the cases, one has to realize that when the court considers an issue and rules on an issue in the way that decides the case, they usually don't reach the other issues. So as the law develops, it develops in a piecemeal fashion. And if a municipality or another government is attempting to implement an ordinance, it's important that they understand what ordinance is going to be permissible and what's not, to the extent you can based on the current law. A landowner who's challenging a city ordinance has to raise specific reasons why the city ordinances are not permissible. And when they go to trial, they essentially have three burdens. They have to plead, they have to produce evidence, and they have to prove their case. Then as they advance to the appellate court, they have to preserve that issue for appeal, and they have to list that issue for appeal. They have to raise that issue for appeal before the appeals court. Along those lines, there was an interesting opinion in the case of City of Grapevine versus Munns. The case was decided by the Fort Worth Court of Appeals, and there was a petition for review to the Texas Supreme Court. The Texas Supreme Court refused to take up the petition and hear the case. And so the reason they said they didn't want to take up that petition is just because there were collateral issues that made that case just a little too complicated. They wanted to take up the issues, but the case wasn't really clean enough for them to take up those issues. Interesting though, in light of considering all the possible claims, there was an opinion by Justice Young that made the observation that the due course of law provisions in the Texas Constitution are worded differently from those in the United States Constitution, and that the law was not developed on what those differences were and what they meant. So anyone who might consider bringing a claim might examine that very carefully because that is a possibility. I discussed this much more in depth in the spring 2025 issue of TG.